Good afternoon. Welcome, everyone. Can you hear me well? Yeah, good. Oh, sorry, I just went too far. Okay, my presentation is going to be a bridge between our second session and the third session. So I'm going to start with, or continue the discussion of what hosting really is. I would like to rethink this concept, especially in the aftermath of the Delphi case. Okay, let's start with Commission's communication, which calls for more efforts and faster progress from all sides to remove illegal contents. I found it surprising to a certain extent because at the same time the European Commission has not really updated the e-commerce directive yet. And the e-commerce directive in its current shape essentially prescribes passivity as opposed to activity. So how are we going to do it? How are we going to actively manage the content if recital 42, the aforementioned recital 42 of the directive clearly says that you should stay passive if you want to enjoy safe harbor protection? I think we're facing a great legal uncertainty today, and the rules are no longer clear and predictable, especially in the aftermath of the Delphi case. So the Google France precedent that was discussed by Martin in depth made it clear that the precondition for enjoying safe harbor protection is being passive. The Delphi case went in the exactly opposite direction, right? And what is interesting about the Delphi case is that Delphi actually responded to the notice immediately. They took the content down. They also have the automatic filtration system, but still they were held liable by the Supreme Court of Estonia. And recently, it means 18 months ago, we've witnessed a similar situation in Poland. There was a case of fact website. It's a well-known journal in Poland, and we had some comments, offensive comments concerning one of very well-known politicians, right-wing politicians in Poland, and the lower courts argued in line with directive on electronic commerce and said that the portal is shielded from liability. But the Supreme Court of Poland, after reading the Delphi case, argued that they shall be liable, despite the fact that, as in the Delphi case, they responded immediately to the notice, they took the content down upon receiving the notice, and they also had the automatic filtration system in place. And this automatic filtration system did its job pretty well, because out of 750,000 comments, it removed automatically 250,000. So almost 1/3 of comments was filtered out automatically. Despite it, the Supreme Court argued that they should have done more. As the Delphi case suggested, if you post the article that can attract a lot of negative comments, you are essentially obliged to monitor postings posted under this very article. All right, so at least in Poland, we face a great legal uncertainty. If you stay passive, right, or whether you stay active, you'll be liable. So the current framework simply does not function. Before I move on and talk more about potential solutions, I would like to highlight two paradoxes of internet regulation. Online content is read more often and circulates longer than the content that you find in traditional media, in newspapers. Yet it's subject to less restrictive rules than the content you find in traditional media. I find it paradoxical. And the second paradox is that existing legal framework encourages providers to stay passive rather than to actively engage in content management. I think this paradox, the second paradox, is a direct result of interpreting the term hosting too broadly, but I'm going to cover this soon. So, there are 3 points that I'd like to make. Firstly, we need to find a way to harmonize Luxembourg and Strasbourg rulings. Right? We need to give a very clear guidance to online platforms how to behave. And we shall design such rules not from the perspective of big players such as Google, Facebook, or YouTube, because these guys are gonna do whatever they please, actually, right? They are too powerful, plus small and medium enterprises, they simply work in a different environment, right? They use different services. They do not have so many resources available. And we need to create rules that are applicable to everyone, not just to the big players. Google, for instance, is both passive and active all the time. So, if you follow the activity of Google, what kind of rules are you going to design, right? For instance, one might argue that natural search is a passive activity. But at the same time, the vice president of Google admits that with respect to extremist videos or content, they are redirecting users to content that might change their perspective, right? I mean, this is really a very active approach to content management that is taken and openly admitted by Google. I will also argue that only providers of hosting infrastructure or data centers shall operate in a technical, automatic, and passive manner to enjoy safe harbor protection. So these rules of Article 14 and 15 do make sense, even today, but mainly with respect to hosting interpreted narrowly. With respect to hosting interpreted broadly, as it is by the legal community, I'm going to argue that we need to develop or fine-tune the existing rules. Especially, we should encourage activity on the side of the service providers. And especially, this is what I'm going to underline, we shall introduce the Good Samaritan rule. They shall not lose protection if they remove objectionable content. Today, we do not have such rule. So if they engage in such an activity, they are losing the protection under Article 14. Okay, but before we get there, do we have rules in directive on the electronic commerce for handling illegal content? The answer is, of course, yes, we do. Article 12 to 15, we've covered this. I would argue that they are rather outdated. And Article 12 to 15 are not the only rules. We tend to forget about the country of origin principle. The country of origin principle established a procedure for blocking a specific information society service provider. But who's using country of origin principle? In the report that was published 2 years after entry into force of Directive on Electronic Commerce, the European Commission admitted that there were 5 cases, all coming from the same service provider. That's it. Right? So we've got the outdated rules that require interstate communication and communication with the Commission. I mean, my God. We don't even know whom to send such a request to, right, these days. Instead of such rules, we should have notice and takedown procedure specified by the European lawgiver. On top of this, we of course have numerous countries of origin principles. So Audiovisual Media Services Directive, Lorna mentioned, right? They've got a separate country of origin principle, which complicates a subject matter further. And of course, we've got 3 types of intermediaries. I'm not going to delve into it. It's been covered. The only point I'm going to make is that all three exemptions, if you look at it from the perspective of what does it apply to, they apply to infrastructure providers. Right? It's just that we interpret hosting very broadly. But both access providers, internet access providers, caching providers, and hosting providers, in its nature, have the infrastructure behind their backs. Okay, these are not the only rules that we've got, not only e-commerce directive. Lorna mentioned other provisions, right? I'm not going to go through it again. But for instance, active role is today required with respect to child pornography and a few other cases. So the rule concerning passivity has some exceptions already today. But let's go back to the term hosting. Well, what is hosting? I would argue that today it's used in such a broad sense that it basically applies to any modern website. Why any modern website? Because nearly all websites these days have text boxes, right? So basically, they take content from the end user, right, and store it somewhere. Even usernames and passwords, any registration forms, it's all about storing content. File uploads. HTML has had these capabilities from its inception. So if we interpret hosting broadly, it's going to apply to almost any modern website. We don't have the definition of hosting, though. The directive speaks only of the storage of information provided by a recipient of the service. Okay, from the technical perspective, it could be questioned. Right? Firstly, hosting is about storing and making it available to the public. Secondly, it's being interpreted broadly by majority of lawyers. It includes, for instance, search engines, right? Social networking websites. But from the technical perspective, and I'm coming also from the IT industry, I've never had a software engineer talking about hosting in the context of a website. We talk about hosting in the context of a company that provides an infrastructure where you can install our applications, right, our databases, but not in the context of a given website. So I would like to argue that we shall distinguish two different categories of hosting. We shall talk about hosting sensu stricto, in the narrow sense, and hosting sensu largo. Hosting sensu stricto applies to data centers. And their job is to provide servers, infrastructure, on which you can install your applications, your databases. So hosting, in the narrow sense, is about also managing domain names. It's about managing multiple websites. What they care about is a number of physical servers and numerous virtual servers, and this is the focus. They do not focus on content management, right? They focus on maintaining infrastructure. Whereas in the narrow sense, in the broader sense, hosting is completely different. Hosting applies to Web 2.0 sites. It applies to website administrators. And these administrators play a different role. They focus on a single service, on a single database, or multiple databases, but relating only to one service. So they really website administrators control the flow of content. In hosting sensu stricto scenario, hosting company does not care about the content that is being processed by the application. So they really perform different roles. In hosting sensu largo, website administrators, they operate under a single domain name, and they really focus on proper functioning of their website, of their platform. And finally, they require hosting sensu stricto to operate. So they are dependent on hosting in the narrow sense. Okay. And the last point is something I would like to underline. There is an interplay between these two types of hosting, right? Hosting sensu largo is dependent on hosting sensu stricto, but hosting sensu stricto manages several, sometimes hundreds or thousands of different platforms, online platforms, and clearly cannot control the flow of content. It's the responsibility of online or website administrator sensu largo to control the website's content. So the relationship between hosting sensu stricto and hosting sensu largo is a relationship between two companies. Right? It's B2B. In most of the cases, this is a B2B relationship. If you take into account end users of websites or hosting sensu largo, they are generating content and they administer, in most of the cases, the content they provided, but they've got usually very limited tooling at the disposal, and it's a B2C relationship. The question that perplexes me is, shall we continue to apply the same safe harbor rules to two distinct types of hosting as we do today? So we adopted this, same size fits all approach. And I wonder whether it makes sense. If you look at the hosting sensu stricto from the perspective of the test, technical automatic passive, I would argue, it makes sense to apply the existing rules to hosting sensu stricto. They operate in a technical manner. They operate automatically, right? So the content that is the application that is being hosted in their infrastructure, they simply leave it to the website administrator. It's your job to make sure that it's operating and it's running. We are not interfering. And of course, they are passive. They are not taking any active steps. They are also very rarely asked to take the content down. In the case of hosting sensu largo, or website, the situation is opposite. I have some troubles with application of technical automatic passive test to website administrators. I think we shall come up with something a bit better, especially this passive part. Most of websites are actually active players. They actively manage content these days. Even if they say they are passive, they are actually actively managing the content. And we shall devise rules that reflect this very fact. And we shall, as I said earlier, encourage them to do so. So we shall protect them from liability when they manage content actively. So what could be done? I would retain hosting provision Article 14 and 15 as it is today, but apply it to hosting understood in a strict way. I think there is a possibility, or there is a possible scenario where we could encourage hosting service providers, understood narrowly, to, for instance, install automatic filtration software. Because if you look at it from small to medium-sized organizations, they usually won't have the resources and sometimes technical possibility to develop such software independently. Right? So it would be easier for a hosting service provider, sensu stricto, to install such software and maintain it essentially for all of the subscribers, for all websites that are being hosted on their premises. Whereas with respect to website administrators or hosting understood sensu largo, I think we shall adopt the active approach, and we shall encourage activity and shield active website administrators from liability. And of course, we shall also adopt clear rules concerning notice and takedown mechanism for website administrators. A side question, this is not a major issue, does it make sense to enact notice and takedown obligation for hosting service providers sensu stricto? Again, I'm looking from the perspective of smaller organizations, not the big players. It's obvious that we shall have such mechanism in case of website administrators, right? But we shall also rethink the mechanism or possibility of asking the hosting service provider, the infrastructure maintainer, to take the content down if, for instance, notice does not work on the level of website administrator. So, to summarize, existing rules for handling illegal content are rather outdated. For instance, the procedure enshrined in country of origin principle does not work. There are many other provisions of this directive that are outdated, not only the ones that are related to intermediaries. For instance, we still have provision for dealing with spam that is no longer, I believe, being applied in majority of member states. We've got Directive 2002/58, which stipulates a different mechanism for handling email-based advertising. I think to clarify the discussion, we shall talk about hosting using two different categories. There's hosting sensu stricto, which refers to infrastructure providers, and hosting sensu largo, which I would equate with website administrators or online service providers. We can come up with a term to describe it. There is also another advantage of this distinction. Hosting sensu stricto is basically a term that would be understood by IT industry, whereas this hosting sensu largo that is used in the legal discussions, it's not really understood. And Article 14 shall be interpreted narrowly, applies to hosting service providers sensu stricto. We shall encourage installation of filtration software and retain the test of technical automatic passive in such case scenario, whereas in the case of administrators of platforms, we shall encourage activity, for instance, not only effective notice and takedown mechanism, but blocking of the content, editorial teams to spot obvious infringements, etc. And maybe this could be a way to harmonize both Luxembourg and Strasbourg judgments, which I think is simply necessary. And I wonder what will be the standing of the Luxembourg Tribunal, which is also required to interpret, according to the Charter of Fundamental Rights, Article 52, this charter in line with the interpretation of the Convention on Human Rights. And last but not least, this Good Samaritan rule, akin to Article 230 of American Communications Decency Act, is something that I believe we need. Intermediaries shall not be at risk of losing protection because of being active editors of harmful content. Okay, and this is it from my side. Thank you very much for your patience, and looking forward to your comments. Thank you.